Okay, we're back for WMU Political Science Class 3250, Criminal Justice Policy. This is online learning section number 2. We'll pick up where we left off at the end of number 1. We're still talking about the Sixth Amendment, and I want to spend this period of time talking about the concepts of fair and impartial trier of fact, pretrial publicity, and then a little bit on the Confrontation Clause and compulsory process. All of this comes from the Sixth Amendment rights that all of us have as citizens. So fair and impartial trier of fact begins on page 460 of the textbook. You'll find a couple of cases in there and a couple of topics from that idea that I think are important to be expressed. When we talk about a fair and impartial trier of fact, what we're talking about is either a judge or a jury in making a decision on whether or not the government has proven that an individual is guilty of a crime. The Constitution demands that the person or persons who are making that decision are both fair and impartial. And how do you make that decision? Well, let's talk about finding out if a judge is fair and impartial. Later on, we'll talk about an individual's right to have a jury trial. Person can waive that right and have a judge hear the case. That doesn't diminish the fact that the judge has to be fair and impartial. So the book talks about a couple of situations that highlight when a judge is not fair and impartial. Toomey versus Ohio at page 461 is a good example of the state of Ohio having a policy which would not permit the judges to be fair and impartial. What happened in the Toomey case is that the judge who would hear a case received their salary based on that judge's ability to collect fines and costs from individuals that were found guilty. That was deemed by the U.S. Supreme Court to be inappropriate. In other words, a judge cannot be fair and impartial if their salary is based on collecting money from people who are guilty. It's not saying necessarily that a judge couldn't be fair and impartial, but the system of that being set up is inappropriate. And so Ohio had to change their method of paying their trial judges because no trial judge under that system could be deemed to be fair and impartial. Another case is Mayberry versus Pennsylvania, again at page 461. In that type of situation, if there was evidence to show that the judge remained distant from the defendant, if a defendant was upset at the judge, and if the judge couldn't have remained distant, that is fair and impartial, based on how the defendant behaved, then the judge shouldn't hear the case. In Mayberry, the judge should have recused themselves. That is, they should have had another judge hear the case, because in that situation, the defendant provided vicious verbal attacks towards the judge and members of the judge's family. And based on that type of behavior on a particular defendant, the judge should have allowed another judge to hear the case. And that judge who was the recipient of that attack couldn't be deemed to be fair and impartial. So we look at examples where the trier of fact, who in a judge-heard trial is the judge, has to be someone who's fair and impartial. Other situations include if the judge himself has a personal interest in the outcome of the case, if they know the victim well or have a relationship to somebody who is a witness, it can't be deemed to be someone who's fair and impartial. You're focusing in on trying to make sure the appearance of impropriety doesn't exist. We don't want to have the trier of fact to at least appear that they're acting in a manner that is improper and not fair to the accused. When we're turning towards the issue of juries, it's the same type of situation. That is, we want to make sure that the juror or jurors are fair and impartial, that they do not have any type of preconceived ideas or thoughts about the guilt of the individual or have a stake in the outcome of the case. Can they be fair and impartial? The way in which this is done in a jury trial is what is known as the voir dire process, V-O-I-R-D-I-R-E. That's the part of the trial where the parties and the judge get to ask jurors questions to determine whether or not they are suitable to hear the case that is before them. So, for example, if a juror might be a representative of Students Against Drunk Driving, spends a lot of their time working on eliminating drunk driving of young adults, and they just so happen to be a prospective juror in a drunk driving case. Clearly, in a situation like that, that juror may not be fair and impartial to the accused. If somebody is a prospective juror who was the subject of a sexual assault and that left a lasting impression upon them, which is certainly understandable, if they are called to serve as a juror in a case that involved a sexual assault, again, they may not be fair and impartial. So this voir dire process is an attempt on the part of the parties, that is the government and the accused, to ask questions to determine whether or not the prospective juror is suitable to be a juror in this type of case. So we'll talk about that a little bit more when we talk about jury trials, but it's important to know that the fair and impartial trier of fact language within the Sixth Amendment is taken seriously, and there are mechanisms in place, should the trier of fact be a judge or a jury, to eliminate those people who are not fair and impartial. Moving on, the book talks about, and I think it's worth noting, the idea of pretrial publicity, which focuses on the fair and impartial trier of fact issue. In other words, if you have cases that have a tremendous amount of interest in the community, either because of the sensational nature of the crime or because the crime involves somebody who might have some notoriety, then pretrial publicity is something that a trial court is required to examine, to curb, in order to make sure that the jury, if they are the trier of fact, is not inflamed by this pretrial publicity. So pretrial publicity begins at page 441 in the book. The judge needs to control the amount of pretrial publicity in order that the jury is fair and impartial in making their decision. The trial court needs to take those efforts to curb whatever pretrial publicity might exist that could influence the jurors. A good example is at page 462, Shepard versus Maxwell. It's referenced in the book, just a little blib in the book regarding this case. Dr. Shepard was a Cleveland doctor who was accused of killing his wife. This happened in the 1960s. As you might imagine, because of his fame and the way in which, I shouldn't say fame, but his notoriety as a doctor, as well as the type of charge that he was facing, a murder charge, it resulted in lots of media coverage. And so what happened in that case is that the trial court did very little to protect the trier of fact, the jury, from receiving this overwhelming amount of media coverage. In fact, I think some of the language in the appellate decisions included it being called a Roman holiday for news media, a carnival atmosphere. In other words, the trial court didn't do much in order to keep the jury from hearing all kinds of information outside of what actually happened in court. And in that particular case, the Supreme Court ultimately overturned the conviction that the jury entered for murder. In other words, Dr. Shepard was charged with and ultimately convicted of murder, and the appellate court, on the basis of it being unfairly prejudicial in terms of the jury, overturned the conviction. Dr. Shepard then ultimately was recharged, and he was never convicted. Obviously, his reputation took a huge hit as a result of this, but this was an example, this case was an example where the obligation of the trial court to ensure that an accused has a fair and impartial jury sometimes has to address the issue of pretrial publicity. There's a movie that's out. It came out, I think, in the 1990s. It's called The Fugitive, involving Harrison Ford, which, of course, is loosely based on this concept of Dr. Shepard. In the movie, Harrison Ford plays a doctor who's accused of killing his wife, and that's where the story has a little bit of a connection to the concept of Shepard versus Maxwell. The rest of the movie doesn't have anything to do with what really happened in Dr. Shepard's case. Picking up on the concept that I just mentioned a few moments ago about fair and impartial trial of fact, trial courts are asked to ask this question when it comes to a prospective juror, and that is whether a juror can lay aside any impression or opinion that they may have based on this outside influence and render a verdict based solely on the evidence presented. So what that says is that if you have heard about an incident and then you ultimately become a prospective juror, that doesn't necessarily mean that you can't be a juror, even if you've heard about it. The idea is whether can you set aside any impression or opinion you may have gathered outside of court in order to focus solely on your role here in court. In the last couple of years, we've had a couple of cases in Kalamazoo that have gained a bunch of notoriety. You may recall the Uber killing. That is the gentleman who was driving an Uber car who was accused of and ultimately convicted of shooting a number of people. There was a case where an individual was driving a car and killed a number of bikers. In fact, 5 bikers died, and a number of bikers were injured. That got a lot of publicity. The issue isn't whether or not you heard about it. The issue isn't whether or not maybe that you immediately formed an opinion about whether or not each of those instances were situations where the person in fact committed the crime. It's whether or not when you come to court, and if you're a prospective juror, you ultimately can set aside that opinion and base a decision on whether or not somebody is guilty solely on the evidence in court. And although it doesn't happen often, occasionally we get these significant type of situations with the sensationalness of the crime and or the individual accused that we have to examine whether pretrial publicity is something that a trial court needs to take account of. Most crimes do not have any pretrial publicity, so it becomes a non-issue. But those that do, you want to look at them. There's a couple of cases in the book that I think are worth noting. There's Irvin versus Dowd at page 463. In that particular case, the trial court inquired of jurors about whether or not they could be fair and impartial. And apparently 8 out of the 12 jurors said that even though they had preconceived notions about the individual's guilt, they could put aside those beliefs and act impartially. The Supreme Court, upon review, decided that the overwhelming number of times that each of those jurors said that they had been prejudiced by the outside information, that is the public attention through the pretrial publicity, their claim that they could be impartial should be given little weight. In other words, when an individual was asked about, did they hear about the case? Did they have an opinion about the case? They said yes, they did have an opinion, they had heard about it, but they could be fair and impartial. Because of the high number of people who answered that way, the Supreme Court ultimately ruled in the Dowd case, that is, again, Irvin versus Dowd at page 463, that their subsequent answer to the question that they could be fair and impartial should be given little weight, and the conviction that they rendered was going to be overturned. The appellate courts have given trial courts a number of things to look at and to examine in order to determine whether or not they are acting in the interest of an accused in curbing pretrial publicity. The things that the trial court should really consider is what is the nature, and there's 4 of them, and I'll talk about them, the nature of the publicity, that is, what was publicized by the media. Was it an inadmissible confession broadcasted on television? That's important. I mean, if in fact the trial court ruled that a confession violated the 5th or 4th Amendment and it's not going to be admitted at the trial, did a prospective juror see that on television and then now come to court and be a juror in a case, and they've got this impression that this guy confessed, but they don't hear it in court? So you look at the nature of the publicity, and that's an important factor to look at. The second thing is, what is the amount and frequency of the publicity? Was there a lot of television coverage? Was there a lot of radio or print media coverage? Did it happen throughout the time period from when the incident occurred through the trial? So the amount and frequency of the publicity is something that is examined by the appellate court to determine whether or not the trial court appropriately reined in the pretrial publicity. The third factor is the proximity of that publicity to the trial. That is, was there a lot of publicity when the incident occurred and then it petered out by the time in which the trial came? Or did it last all the way through the trial, if you will, on a daily basis? And what did the judge do in order to make sure that the trial, that is, the jurors in the trial, did not get that information? And this is where sometimes judges order sequestration orders. The word sequestration, sequestration, that's an opportunity for a judge to order that jurors refrain from doing things. It could be so much as saying to a juror, you're not allowed to read newspaper or watch television coverage while you're a juror, in the hopes that you won't pick up some of this outside information. And it can lead to the extreme where a juror is, or I should say not just a juror, but the entire jury is sequestered into a hotel, if you will, where they don't have access to the outside public. Now that example is rarely used, but it may be used in order to keep them from being influenced by outside information. Oftentimes there's a requirement that you can't read the newspaper, don't go on social media, don't watch television when there's a case that has some publicity. When it's really published and really out into the community, then it may require that a judge order that the individuals who are on a jury stay completely away, that is, locked up in a hotel room while they're a jury. The fourth and final thing that is to be considered to determine whether or not the trier of fact has been prejudiced is, what did the judge do during the voir dire in exposing the prejudices? And this is where a trial court has a specific responsibility to make sure that these questions are asked of prospective jurors in order to determine whether or not they have been influenced by this publicity prior to serving as a juror, and what they are doing when they sit on a jury to avoid the publicity. So an aggressive approach on the part of the judge is important when you're handling these high-profile type cases. The concept is, of course, in a jury trial of a significant magnitude, is to get the total number of jurors, whether they're 6 jurors or 12 jurors, that are impartial and can render a decision based on the evidence in court and only in court. So the next part of the chapter here talks about various ways in which the courts have attempted to control the exposure from the media. That is, doing things to the media to limit the amount of exposure to the general public for purposes of possible jury trial down the way. So let me talk about 3 cases, the first of which is Nebraska Press versus Stewart at page 465. In that situation, the trial court decided to gag the media. That is, the trial court ordered that the media not publish anything about the case. The circumstances of the Stewart matter was that there was a murder of 6 family members in a rural community in Nebraska, and the judge, because of the sensational nature of the crime, the judge ordered that the media not publish information gathered in court about the case. In other words, trial courts began to close the courtrooms to the media in order that they not get this information to publish it. And the Supreme Court ruled that judges cannot order media from publishing information that they've gathered. The trial courts are not allowed to go ahead and order that a media or levels of media cannot publish information that they've gathered. In other words, if the media has the information, they're entitled to publish it. So what the courts tried to do then in response to the Stewart case is then, well, let's see if we can think of ways in which we can avoid the media from even getting the information, and that is closing courtrooms to the media. So if I have a pretrial hearing where I'm making a decision whether or not a confession gets introduced, I decide I'm going to ban the media from coming to the court. Or if I do not want them to publish anything about what's happening during the trial, I'm going to ban them from coming to the trial. Because of the Stewart decision, that is Nebraska Press versus Stewart, where the Supreme Court ordered that trial courts cannot ban the media from publishing information they've gathered, the next step maybe the court would like to do is to keep them from gathering the information in the first place. So once the Nebraska Press versus Stewart case came out, the response by the trial courts is to close courtrooms to the media, which leads us to the second case, Gannett versus DePasquale, which is at page 466, Gannett being a newspaper company. And in that particular situation, the trial court limited the media from attending the pretrial hearings because following the Nebraska Press versus Stewart decision, if we can't keep them from publishing that which they've uncovered, let's keep them from uncovering the information. The Supreme Court in the Gannett case, which is referenced at page 466, indicated that trial courts are not allowed to completely ban the media from court proceedings. What they did say in Gannett is that they can, that is, a trial court can limit the media at a pretrial hearing. That is, prior to the trial. If these things exist, then a trial court can ban the media from coming in. And the first is that there's a substantial probability that publicity from an open proceeding would compromise the defendant's right to a fair trial. And the second is that alternatives short of closing the courtroom would be inadequate to protect the defendant's right to a fair trial. In other words, if a trial court made that decision that there's a substantial probability that the publicity would compromise the defendant's right, and there's nothing else that the court felt is it could do other than close the courtroom, then the court is permitted to limit the media at a pretrial hearing. In other words, I can ban the media from coming to a pretrial hearing. Now, this is a difficult decision to make on the part of the judge because, again, we talk about the Sixth Amendment right for the defendant to have a public trial, that is, to allow the public in court. There's the First Amendment right from media to be in court. In the Gannett case, the Supreme Court weighed all of this and said for pretrial hearings, when those things exist, you can ban the media from coming in. The Supreme Court said that it was unconstitutional to order everyone out of the courtroom during the entirety of the trial. So when it came down to can you do the same thing that Gannett said during the course of a trial, and in the case of Richmond News versus Virginia, which is at page 466 in your book, it's only in a footnote, I think it's footnote 133, the Supreme Court ruled that while you may be able to ban the media at pretrial hearings, you cannot ban everyone from the courtroom during the entirety of a trial. Richmond News versus Virginia was a trial court decision to keep the media out during the entire trial, but that was found to be unconstitutional. So what we have when it comes to media being in the courtroom is that once the media gets the information, you can't gag them from presenting it to the public. You can limit the media's presence at hearings prior to a trial, that is in a pretrial proceeding, but you can't completely ban the media from the courtroom during the entirety of a trial. In those cases, Nebraska Press versus Stewart, Gannett versus DePasquale, and Richmond News versus Virginia highlight those issues. One thing the court can do in an effort to curb pretrial publicity is that the court can order that the players in the trial, that is the prosecutor, the witnesses, the defendants, order that those people not speak to the media. You have control over the participants, so you can order that they not speak to the media about what is transpiring in court. But once the media gets the information, there's very little that the trial court can do to curb the media from publishing it and providing it to the public. Once the public has that information, as we talked about a couple of minutes ago, the court has to take those steps in order to ensure that in order for a defendant to have a fair and impartial trial of fact and get such a fair trial, those prospective jurors are not overly influenced by that attention. Moving on to the last topic for this particular session, that is the Confrontation Clause and compulsory process. Again, these come from the Sixth Amendment, which means they don't begin for an accused until the person has been charged with a crime. The Confrontation Clause means that an accused has a right to confront those who testify in court. That is, the Sixth Amendment permits and provides for an accused to be able to confront the accuser in court. And the reason for that is multiple, really. If a person is under oath and under penalty of perjury in court, in open court, where the accused has the right to confront them, it's more likely to be the truth that they're talking about. The defendant having a right to confront the witnesses in court also allow the jurors to evaluate and determine the credibility of the witnesses. In other words, if the defendant had no ability to cross-examine the accuser, is it the best for the jury to assume just what they're saying is to be truthful? You need to have that opportunity for a defense attorney on behalf of his client in ensuring his right to a fair trial and to confront his witnesses, to poke holes, if they exist, at an individual's version of what they saw. So, through that cross-examination, the accused has the right to attack the credibility, the veracity of a witness that may impact ultimately whether or not a juror finds the witness to be credible. One exception to the Confrontation Clause is when you're dealing with sexual assault victims, in particular child sexual assault victims. As I mentioned before, when we talk about closing a courtroom for the public trial aspect of the Sixth Amendment, sometimes a trial court may prohibit an accused from confronting the accuser if the accuser happens to be a child sexual assault victim. If the courtroom would cause a serious emotional trauma such that the accuser may not be able to speak while the accused is in the courtroom with them, the court sometimes, in those limited circumstances, may be able to set aside the individual accused's right to confront their accuser. So, for example, if the defendant happens to be the uncle of a 9-year-old sexual assault victim, and the 9-year-old sexual assault victim is coming to court to testify and realizes there's a determination that the accuser is not going to be able to testify in court while the accused is sitting at the defense table a few feet away, then the court may take steps to distance the accuser from the accused, which would be a direct violation of the Confrontation Clause. Again, the Confrontation Clause permits the accuser to confront their witness. So what happens in those situations? Well, sometimes a closed-circuit television setup goes into play where the defense attorney might cross-examine the accuser in a room outside of where the accused is. So maybe you go into the judge's chambers, you set up a closed-circuit television hookup where the jury and the defendant can see the cross-examination by the defense attorney, but the accuser is not actually in court having to look at the accused. Sometimes you put up a wall such that the accuser doesn't have to see the accused. That is, maybe you put up a barrier in the courtroom in order to foster the opportunity for the accuser to actually speak about what happened to them in a particular incident. So these are mechanisms, that is that closed-circuit television hookup, as well as maybe a physical barrier that appear to violate the Confrontation Clause, but are measures that are deemed to be appropriate in certain circumstances. That is, when you have a vulnerable, tender-age victim who may have suffered a serious traumatic event as a result of how the accused behave. So that's the Confrontation Clause. Again, the Sixth Amendment provides the defendant an opportunity to confront those witnesses who are going to testify against them, with those limited exceptions. The last part of the Sixth Amendment here that I want to talk about now is compulsory process. The idea of compulsory process is to afford an accused the opportunity to bring witnesses in for their defense. That is, the court has to assist an accused in getting witnesses that may help the defense. That is, the court provides orders to order that reluctant witnesses who may have information that may be helpful for the defense to come to court to provide that information in open court. If I'm somebody who's accused of a crime and I know that my neighbor saw me that day such that he would be an alibi witness, but he's reluctant to come in and testify, as an accused, I can ask that the trial judge issue an order requiring that the witness come in, the neighbor come in to testify to what they recall. That's a concept we refer to as compulsory process, compelling witnesses to come to court to assist somebody who's an accused. If I'm somebody who's accused of a crime and I'm sitting in jail and I'd like somebody to come help me out and tell what it is that they saw or be my alibi, if I can't get out there and encourage them to show up, is that just? And the answer is no. I need the court's assistance in doing so, and that's done with compulsory process. So that wraps up the topics that would stem from the March 11th, 2020 syllabus. It's the end of what I'll call online learning number 2. The next one will be online learning number 3, and we'll pick up with grand juries, arraignment, pleas, and plea bargaining. Thank you.